We're just going to give everybody a second to join before we get started. All right, I'm going to go ahead and get started. Good morning, and thank you for joining us for Title IX in the Trump era. Today, we will be giving a legal update on Title IX to include what's happening with all the lawsuits over the Biden-Harris Title IX rule, regulation changes, including what the rule being vacated by federal courts means, as well as how Trump's executive orders play a role. We'll also be giving an update on how these changes affect the questions surrounding bathrooms and athletics, as these are primarily the topics that we receive questions on. At the end of the presentation, we will have a short Q&A, so if you have any questions during the presentation, please send them at any time using the Q&A function at the bottom of your Zoom screen. This webinar is being recorded, so after the webinar is over, we will be sharing it on our Wisconsin Institute for Law and Liberty YouTube page, and everyone who has signed up will receive a link to that recording. My name is Lauren Greuel. I am Associate Counsel at the Wisconsin Institute for Law and Liberty, and I primarily focus on K-12 litigation and policy issues. With me is Deputy Counsel Luke Berg, who is one of Will's Title IX experts and who leads many of our legal efforts in this area. Now, just a little bit about the Wisconsin Institute for Law and Liberty. Will is a nonprofit law and policy center in Milwaukee, Wisconsin. Through education, litigation, and participation in public discourse, we work to advance limited government, free speech, transparency, and education reform. We provide timely and comprehensive public policy research to advance education reform, election reform, economic reform, and policies to advance limited government. So just to give an overview of the presentation, we are going to cover 4 major topics today. First, I'm going to go over the legal updates on Title IX, as well as how the new administration's executive orders and Dear Colleague letters have affected the Title IX rule. Then Luke is going to address the bathroom and locker room issue and the athletics issue in light of this new presidential administration. In our last webinar, Will discussed changes to Title IX regulations by the Biden-Harris administration. For those who are unable to join us or are unfamiliar with what happened, I'm going to give a brief overview. So, what is Title IX? Title IX of the Education Amendments of 1972 prohibits discrimination on the basis of sex and applies when a recipient, oftentimes a school district, participates in a program or activity that receives federal financial assistance. Congress enacted Title IX in order to give women equal opportunity to aspire, achieve, and participate in and contribute to society based on their individual talents and capacities. It prohibits educational institutions from discriminating on the basis of sex, while allowing schools to maintain sex separation in some programs to equalize opportunity for girls and to protect the privacy interests of all. So you might be asking yourself, how did the Biden-Harris administration change Title IX? On April 19, 2024, the Biden-Harris administration, through the Department of Education, released the final version of the updated Title IX regulations. The updates given to Title IX completely undermined the original meaning of Title IX. In particular, the new regulations changed what the definition of sex discrimination means to include discrimination on the basis of gender identity. Adding gender identity to the definition of sex discrimination means that biological men would have access to women's spaces, and anything schools do to protect biological women could constitute a Title IX violation. The new regulations also eliminated due process protections that can be construed to infringe on parental rights and to chill or compel speech. The Biden-Harris administration told schools that they must comply with these changes to Title IX by August 1st, 2024, or the schools could be investigated and risk losing federal funding. If you're interested in all the changes that the Biden-Harris administration made, Will partnered with the Defense of Freedom Institute and the Southeastern Legal Foundation to put out a comprehensive guide for school boards on November 12th of 2024, which is going to be linked in the chat. So there you go. Because of how drastic the changes to Title IX were, it's unsurprising that lawsuits began to pop up all over the country challenging these new regulations. There were at least 9 cases filed in federal court challenging the Biden-Harris Title IX rule. I'm going to cover the case that went all the way up to the Supreme Court of the United States, and then the 2 cases that issued final decisions so far. Those are Louisiana versus Department of Education, Tennessee versus Cardona, and Carroll Independent School District versus United States Department of Education. Both Louisiana versus Department of Education and Tennessee versus Cardona are the cases that focus primarily on 3 provisions of the Biden-Harris rule. First, that sex discrimination includes discrimination on the basis of gender identity. Second, bathrooms and locker rooms. And third, the definition of hostile environment, which can include subjectively offensive conduct. In June, both federal trial courts issued preliminary injunctions blocking the Biden-Harris Department of Education from enforcing any part of this rule. These injunctions were then appealed to the Supreme Court of the United States, where the Biden-Harris administration argued the injunction should not be allowed. The Supreme Court ultimately turned down the Biden-Harris administration's request to be allowed to implement the new Title IX rule and upheld the Federal Circuit Court's preliminary injunctions. It's important to go over what happened with the Supreme Court because there were some misconceptions about what the Supreme Court ruling meant. The Supreme Court ruling did not vacate the 2024 Title IX rule. Instead, it gave federal courts permission to issue preliminary injunctions to block the rule from being enforced while the rest of the litigation played out. And litigation has continued to play out. In Tennessee versus Cardona, it was filed in Federal Circuit Court of the Eastern District of Kentucky. The court determined on January 9th, 2025, that the Biden-Harris rule was invalid on several grounds. Primarily, the court found that the Department of Education had exceeded its statutory authority because while Congress gave the department authority to issue rules, regulations, and orders to effectuate Title IX, there's nothing in the text or statutory design of Title IX to suggest that discrimination on the basis of sex means anything other than it has since Title IX's inception, which is male and female. The court also determined that the Biden-Harris rule violates the Constitution of the United States because it would require Title IX recipients, including teachers and students, to use names and pronouns associated with a student's asserted gender identity. However, the First Amendment to the United States Constitution does not permit the government to chill or compel speech, and affirmance of a belief with which the speaker disagrees would likely violate the First Amendment, and it would, according to this new rule. Because of these issues, as well as several others, the court found that the entirety of the Biden-Harris Title IX rule should be vacated and states and their recipient schools need not comply with the rule to receive federal funding. This means that the rule is no longer effect anywhere in the United States. While the circuit court ruling still governs how schools should handle Title IX right now, an appeal by two proposed interveners was filed on Monday, March 10th, 2025. This means that the Sixth Circuit Court of Appeals will review whether the Eastern District of Kentucky Circuit Court got the ruling right. One of the groups is appealing to defend the Biden-Harris Title IX rule with respect to sexual harassment investigations, and the other is appealing to defend the rule with respect to the parts of the rule that apply to pregnant and postpartum women. So far, no one has tried to intervene to defend adding gender identity to the definition of sexual discrimination, so that part of the rule is gone and is very likely not coming back. In another one of the cases challenging the Biden-Harris Title IX rule, it has also been concluded that vacating the rule is appropriate. On February 19th, 2025, in Carroll Independent School District versus United States Department of Education, which was filed in the Northern District of Texas, the court determined that the Biden-Harris rule violates the First Amendment by compelling speech. The court also found that the rule is contrary to law, arbitrary, and capricious. The court summed up this finding by saying, quote, "Because the discrimination between male and female is at the heart of Title IX, throwing gender identity into the mix eviscerates the statute and renders it largely meaningless." End quote. The deadline to appeal this decision is April 20th, but no appeals have been made as of today, March 12th, 2025. So if the Biden-Harris rule has been vacated by several federal courts, where does that leave Title IX today? First, the Trump administration has made it clear that it will not appeal or defend the Biden-Harris Title IX rule, and therefore, once the federal courts have had their final decisions made, that is where the decisions will stay and they will not change. Second, because the Biden-Harris Title IX rule was vacated, the controlling Title IX rule has reverted back to the 2020 Title IX rule that was implemented by the first Trump administration. Which brings me to the next part of the presentation, which is how Trump's executive orders and Dear Colleague letters play a role in everything that is happening with Title IX. Will hosted a webinar 2 weeks ago analyzing the Trump executive orders, which is available on the Wisconsin Institute for Law and Liberty YouTube page if you're interested in a more thorough history and background of the executive orders. You should check that out, and I'm going to link it in the chat as well. As a brief overview, an executive order is a policy statement from the president and an official document whereby the president issues directives for the managing and administering of federal agencies. These orders cannot conflict with the Constitution, federal law, or violate the separation of powers. As a check on executive orders, courts can strike them down as unconstitutional, or Congress can pass a law effectively overturning an executive order. A Dear Colleague letter is an official correspondence used by a member, committee, or officer of the United States House of Representatives or Senate to communicate with their colleagues, often to encourage, support, co-sponsor, or oppose a bill, issue, or policy. I'm going to go through some of the executive orders and Dear Colleague letters and discuss how they may affect Title IX, and we'll take them in chronological order. The day President Trump was inaugurated, January 20th, 2025, he signed an executive order titled Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. This executive order directed each agency and all federal employees to enforce laws governing sex-based rights, protections, opportunities, and accommodations to protect men and women as biologically distinct sexes. This includes taking appropriate action to ensure that intimate spaces designated for women, girls, or females, or for men, boys, or males, are designated by sex and not by gender identity. This executive order also states that federal funds shall not be used to promote gender ideology. Importantly, and we'll reference this later, this executive order gives definitions for what sex, women, men, male, female, and gender ideology are. Sex is defined as an individual's immutable biological classification as either male or female. Sex is not a synonym for and does not include the concept of gender identity. Woman is defined as an adult female human, and man is defined as adult human male, and so on. On January 29th, 2025, President Trump signed an executive order titled Ending Radical Indoctrination in K through 12 Schooling. This executive order requires a review into each agency's process to prevent or rescind federal funds to maximize to the extent consistent with applicable law, elementary schools, secondary schools, or anything that directly or indirectly supports the subsidizing of the instruction, advancement, or promotion of gender ideology or discriminatory equity ideology in K through 12 curriculum, instruction, programs, or activities. For example, part of the discriminatory equity ideology is defined as an ideology that treats individuals as members of preferred or disfavored groups rather than individuals and minimizes agency, merit, and capability in favor of immoral generalizations. That is already part of federal law. Students cannot be treated differently based on their sex, which is Title IX, or race, which is Title VI. So part of this executive order is ordering a review into the agency's processes and funding for gender ideology in K through 12 schools, but some of it is already covered by federal law. And as of right now, this order is directed primarily at agencies to come up with a plan and does not directly instruct schools to do anything. However, schools should be made aware that a plan is coming and their federal funding is at risk if they continue to teach gender ideology or DEI. On February 4th, 2025, a Dear Colleague letter from the United States Department of Education, Office for Civil Rights, was published. The letter referenced Tennessee versus Cardona, which we already went over, saying, quote, in light of a recent court decision, the United States Department of Education's Office for Civil Rights will enforce Title IX under the provisions of the 2020 Title IX rule rather than the 2024 Title IX rule. As such, any open Title IX investigations initiated under the 2024 Title IX rule should immediately be reevaluated to ensure consistency with the requirements of the 2020 Title IX rule and the pre-existing regulations, end quote. So while the 2020 Title IX rule does not necessarily define sex discrimination as discrimination based on biological sex exclusively, the Trump administration has made clear that in any of its implementation of Title IX, it will interpret sex to mean biological sex consistent with the original text and intent of Title IX. On February 5th, 2025, President Trump signed an executive order titled Keeping Men Out of Women's Sports. Luke is going to talk about this a little bit more in his section, but I wanted to quickly highlight what it says and why it's important to our Title IX discussion. This executive order specifically states that under Title IX of the Education Amendments Act of 1972, educational institutions receiving federal funds cannot deny women an equal opportunity to participate in sports. Therefore, it is the policy of the United States to rescind all funds from educational programs that deprive women and girls of fair athletic opportunities, which results in the endangerment, humiliation, and silencing of women and girls and deprives them of their privacy. The Office of Civil Rights has already opened 3 Title IX investigations into K through 12 schools who have been openly violating this executive order since it was passed. You may have seen the exchange between President Trump and the governor of Maine, and that was one of the states that a Title IX investigation was opened up into. Those schools were continuing to allow transgender female students or biological male students to participate on sports teams. The Office of Civil Rights has already closed 2 of those investigations because the schools in those states have agreed to discontinue this practice. On March 5th, 2025, a draft of an executive order to eliminate the Department of Education was shared with the Wall Street Journal, and Secretary McMahon put out a statement on March 3rd, 2025, titled "Our Department's Final Mission." Then, yesterday, March 11th, the Department of Education initiated a reduction in workforce, or RIF, that will continue to reduce the department's workforce by 50%. While the topic of eliminating the Department of Education could be an entire webinar in and of itself, I did want to briefly touch on what this could mean for Title IX. As I said at the beginning of this presentation, Title IX is regulated by the Department of Education and enforced by the Office of Civil Rights, or OCR, under the Department of Education. The OCR handles most Title IX complaints that are filed across the country. However, Title IX is part of the Education Amendments of 1972. And for context, the Department of Education was only first created in 1979. As such, if the Department of Education was dismantled or eliminated completely, Title IX would still be good law, and the enforcement mechanism would likely be taken over by the Department of Justice, or DOJ. The DOJ currently handles some of the education-related Title IX and Title VI complaints that are filed every year. The Trump administration, or the Trump Department of Education, has also launched several Title IX investigations since his inauguration over men and women's sports teams, and one on all gender-inclusive bathrooms. So if the Department of Education were to go away, those would be taken over by the Department of Justice, more than likely. So that covers some of the legal updates and some of the executive orders and dear colleagues letters that affect Title IX. And with that, I'm going to hand it over to my colleague Luke Berg, who's going to address the bathroom and locker room issues, as well as the athletic issues.
Well, thanks, Lauren. As Lauren said, I'm going to cover those 2 issues in part because it's a bit complicated and there's a lot of moving parts. So I'm going to do my best to sort of summarize where each of those issues stands currently. I'm sure those of you listening are going to have questions. And so if you do, please put them in the Q&A and we'll be happy to answer them as we go. Okay, so the Biden-Harris Title IX rule pretty clearly required schools to allow transgender students to use whatever bathroom and locker room they identify with. As Lauren discussed, that rule has been vacated, is no longer in effect, and so we revert back to the 2020 rules. So where does that leave us? So as of 2020, Title IX has had, and for a long time has had, a clear rule that specifically says that schools can provide separate restrooms and locker rooms on the basis of sex. Now, you can see the text right there. It's very straightforward. So this should be one of the easiest legal questions there is, but the Seventh Circuit, and I'm going to explain what that is, in a few cases has held that Title IX actually requires the exact opposite of what it says. And those decisions were issued not under the new rules, but under the old Title IX rules. And so those cases are still in place as of today. So 2 separate cases from the Seventh Circuit. One was in 2017. It's called Whitaker. It was brought against the Kenosha School District in Wisconsin. And then in 2023, a case called AC brought against a school district in Indiana, and the Seventh Circuit basically doubled down on its prior reasoning. And in both of these cases, the facts were a transgender student sued the school district. The district had a policy of limiting bathrooms based on biological sex, and the court held in a preliminary injunction posture that the school districts had to allow that student to use the bathroom they identified with. Now, an important note here, and I'm going to come back to this, both cases had two rationales, both Title IX and equal protection. So it was a constitutional basis and also a Title IX holding. So the main question that a lot of people have is, are these cases binding law on other school districts? Do other school districts have to follow these decisions? And to answer that, you have to know a little bit about the federal court system and how precedent works. So our federal court system has three levels. The Supreme Court is the top, the one everybody knows about. It has the final say on any legal questions that involve federal issues. Federal trial courts at the bottom are divided into districts. States often have more than one district. So Wisconsin has two, the Eastern District of Wisconsin and the Western District of Wisconsin. And in between trial courts and Supreme Court is the Court of Appeals, which is divided into 12 circuits. So we are in what's called the Seventh Circuit, which covers Wisconsin, Illinois, and Indiana. And the general rule is any case, any federal case, there's a few exceptions, but most federal cases start at the district court and they work their way up, and each court above can overrule the courts below it, and courts below the top have to follow decisions from the courts above them. So the question then, coming back to the question, are other districts legally bound by these two cases, and do they have to follow Whitaker and AC? And the answer is yes and no. I apologize, I have to give the lawyerly answer. But there's two different senses that lawyers think about when they hear this question about legally bound. So there's a strong sense of decision being binding. This only applies to the parties in the case. So the Kenosha School District and the particular student, the court has issued a final order with respect to that student and that school district. And if that school district were to ignore that order, it could be held in contempt. It could be fined, and even jail is a remedy for contempt. That kind of really strong binding only applies, again, to the parties in the case, doesn't apply to other districts. So if other districts are sued on the same issue, they're not going to be held in contempt. They might lose, but they're not going to be held in contempt. The second sense is sort of weaker, and this is what lawyers call precedent. So any decision that's issued by either the Seventh Circuit or the Supreme Court becomes a precedent that other district courts in the Seventh Circuit have to follow. That's not true of district court decisions. So if one judge in the Eastern District issues a decision, another judge in the same district, even on the same question, can come to the opposite conclusion. But once a case goes up to the Seventh Circuit or the Supreme Court, it becomes a precedential opinion that trial courts in the Seventh Circuit then have to follow. So this applies in any future case brought in a federal court in Wisconsin, Illinois, or Indiana, unless, and this is the next slide, there are sort of four different ways that a district who sued on this issue could potentially argue against these cases. So, and this is the way lawyers typically think about precedent. And the way I want you all to think about it is if a school district says we're going to limit bathrooms based on biological sex, they get sued by a transgender student. Could they win? Do they have any way that they could win that case? And what are sort of the arguments that they could raise, the kind of arguments that lawyers make? So the first kind of argument that lawyers make is to distinguish the prior case, either on the facts or they bring a new legal argument. So some of the facts that the Seventh Circuit emphasized in those prior cases were sort of what neutral bathroom options were available, how far away were they, did the student accurately document that they were transgender so that the school could be assured it wasn't just somebody faking it, that sort of thing. Or school districts could potentially try a different legal argument. So since Whitaker and AC were decided, half a dozen or so, maybe more, school districts have tried to distinguish those cases on their facts or by bringing different legal arguments, and every single one of them has lost so far that I'm aware of. So this is very unlikely to be successful at the trial court if a school district was sued on this issue. The second type of argument that a district could make would be to say that events have changed since those decisions were issued, such that there's a change in the law and those decisions are no longer good law. Now, AC was issued in 2023, so it'd have to be something relatively recent. But as Lauren mentioned, one of the cases against the Biden rule went up all the way to the US Supreme Court. Now, it wasn't a merits ruling, it was in a stay posture. So the Biden administration was asking the court to limit the preliminary injunctions against its rule and allow the rule to go partially into effect. But one of the issues that was squarely presented to the court was the change to the new rule, adding gender identity to the definition of sex discrimination. The Biden administration asked the Supreme Court to limit the injunction so that that part of the rule could go into effect. And the Supreme Court held 9-0, all nine justices agreed that that portion of the rule could not go into effect. So that is a very strong signal about what the Supreme Court thinks about the premise of the Biden Title IX rule. And the premise of the Biden Title IX rule happens to be the exact same premise as both of these Seventh Circuit cases. In fact, it invoked those two cases as support for its rule. So this is a strong indication that if the case reaches the Supreme Court, it's not going to agree with the Seventh Circuit's rationale. And I think there's a good argument to be made that the Supreme Court stay decision currently undermines those two Seventh Circuit cases. That issue is actually currently being litigated in a case in the Eastern District of Wisconsin. So it remains to be seen what a district court will say about that. And that's a pending issue currently. Sort of the third way that a school district could litigate the issue if it were sued is it could try to take the case all the way up to the Supreme Court and ask it to overrule the Seventh Circuit's decision in Whitaker and AC. And again, any school district that was not a party to one of those prior cases has a right to litigate their own case and has a right to try and take the issue all the way up to the Supreme Court. There are three cases currently pending in the Seventh Circuit, one against the Elkhorn School District, one against the Mukwonago School District. Those are both in Wisconsin, and then one against the Martinsville School District in Indiana. And each of those cases, the school district could try to take it all the way to the US Supreme Court. We're not there yet, but that could happen in the future. In my opinion, if a school district were to take the issue all the way to the US Supreme Court, it would be highly likely to succeed, and the Supreme Court very unlikely would agree with the Seventh Circuit's holding in Whitaker and AC. And in part, that's based on the stay decision that I've already discussed, where all nine Supreme Court justices agreed that the Biden rule should remain enjoined, in particular, the key provision that redefines sex discrimination to include gender identity, but also just based on the text of Title IX. It's actually not a very close question. As I showed the text previously, Title IX says explicitly that schools can separate bathrooms based on biological sex, and the Seventh Circuit's holdings effectively hold the opposite of what the text says. So I don't think the analysis is very persuasive, and I don't think it's very likely to survive if it ever gets to the US Supreme Court. The problem here is the Supreme Court doesn't take every single case that's wrong. It only has limited time to take certain cases. So it just depends on whether the Supreme Court will take the case. And of course, it's costly and time consuming for a school district to have to litigate it all the way up to the Supreme Court. And these three cases that are pending, while they're currently in the pipeline, it's not going to happen soon. It could take a few years before any of these three cases get up to the US Supreme Court. So the sort of fourth option that could happen with these two cases, Whitaker and AC, is they could be indirectly overruled by another case. So if there's a case before the court on a closely related issue, not the exact same question, bathroom issue, but if it's closely related enough, the Supreme Court could say some things that could undermine the reasoning in Whitaker and AC, and they could be indirectly overruled. So there's sort of two cases to mention briefly here. There's one currently pending before the US Supreme Court called Skermeti. This is a challenge to a state law that bans giving puberty blockers and cross-sex hormones to children. The legal theory here is an equal protection claim. So the exact same theory as one of the two halves from Whitaker and AC. That case was argued in the fall and is likely to be decided in the summer. And based on how the arguments went, it seems pretty likely that that decision is going to undermine the equal protection rationale of Whitaker and AC. But again, this is only the equal protection half. There is no Title IX question presented in Skermeti. The second case that's currently pending before the court, it hasn't granted review yet. There's a cert petition pending, is called West Virginia v. BPJ. This is a West Virginia law that limits sports based on biological sex. The lower courts held that this law violates Title IX. So this case does have the Title IX question presented in it. And there's currently a cert petition pending, but the court hasn't taken it yet. Oddly, it's been just sitting on the case for a while. And I think it's waiting until it issues its decision in Skermeti and then is going to decide what to do with this West Virginia case. So if it takes the West Virginia case and reviews it on the merits, I think there's a very good chance that it will undermine Whitaker and AC. If it doesn't, then it won't. So the bottom line is these two cases, Whitaker and AC, in my view, are very unlikely to survive when the issue eventually reaches the Supreme Court, but it could take a few years. And in the meantime, if a district gets sued on this issue, there's a decent chance that they will lose at the trial court and they need to be prepared to appeal and to litigate it. All right, so I'm going to turn now to the sports issue. An amendment to Title IX in 1974 required the department who implemented Title IX at the time to pass rules to address athletics. That department adopted those rules in 1975, and then Congress had a chance to review and disapprove them. It did not disapprove them, so they went into place in the 1970s, and those rules have been in place since the 1970s. And those rules do three main things. So the first thing they say is pretty explicit that schools can have sex-separated sports teams for any competitive sport or for a contact sport. Anything else, they can't discriminate on the basis of sex, but that only includes sort of recreational, non-contact sports. So most of the sports that we think of tend to be either competitive or contact sports. So the general rule is you can have sex-separated teams. So the second thing it does is it says that women must be allowed to try out for some men's sports, sports that are non-contact sports, and only if no women's team is offered. And then the third thing, and this is sort of the main thing that people think of when they think of Title IX and athletics, it requires schools to provide equal athletic opportunity for members of the opposite sex. Now, this is complicated. This doesn't require the exact same sports or the exact same numbers, but this is about overall opportunities. So the sort of number of sports in total that the school offers, the facilities, the coaching, funding is relevant, although exact equality in funding is not required. So it's complicated, it's fact-based, but just sort of the general high-level principle is that schools have to provide equal athletic opportunities for both sexes. So into this background comes the Trump executive order on February 5th that Lauren talked about. The executive order says that schools now must limit girls' teams to biological girls or they risk federal funding. if they don't. And as Lauren mentioned, the Trump administration is already bringing enforcement actions based on this executive order against school districts. Now, this executive orders can't change the law. So this executive order is based on the equal opportunities portion of Title IX that I just covered. And the idea is if you force women to compete against men, they don't actually have equal opportunities to men because they are being displaced by men in their sports. The Second Circuit, there's a pretty well-known case in the Second Circuit that has already accepted this as a potentially viable claim. So this case involves track athletes in Connecticut, and there are two male transgender runners who were pretty dominant and won a lot of races and championships and displaced girls, took away championship opportunities and scholarship opportunities from the plaintiffs in these cases. This case went up to the Second Circuit, actually en banc, which means every judge in the Second Circuit weighed in. And they sent it back to the trial court and said, this is potentially a viable theory and we're going to have a trial. So the case is proceeding to a trial in that case. And all that is to say that the theory represented in the Trump administration executive order is a very viable, legitimate theory that courts have already recognized. So after Trump's executive order, a lot of athletics associations changed their rules. The Wisconsin Interscholastic Athletic Association, the WIAA, changed its rule and says now that transgender students cannot compete on girls' teams. But this only applies to competitions. The WIA rule still allows transgender students to practice with the team and to change in the locker room, but it just says that transgender students cannot compete. The NCAA also changed their rule in the same way as the WIA. It only addresses competitions. 25 states have passed laws similar to Trump's executive order that say women's sports have to be reserved for women. There is currently a bill pending in Wisconsin. Wisconsin doesn't have a law yet, but there is currently a bill pending. So it remains to be seen what happens with that bill. Like with the bathroom issue, some courts, there have been cases challenging some of these laws, the 25 that I just mentioned, and some courts have held under Title IX that these laws violate Title IX such that schools may not exclude transgender athletes from the girls' team. Now, to my mind, again, I think this is directly at odds with the text of Title IX. Here's the text that says explicitly that schools can have sex-separated sports teams. So I don't think this should be a hard legal question, but it is what it is. Some courts have held that Title IX does not allow what it explicitly says it does allow. So the most prominent of these cases is a Fourth Circuit case, the one I already mentioned, against a West Virginia law. The Fourth Circuit held that the West Virginia law was illegal and violated Title IX. And there's a cert petition currently pending in the case. Again, I think if the Supreme Court takes the case, it's highly likely that it will overrule the Fourth Circuit. But it has been sitting on this cert petition for quite a while, longer than I would expect. So my guess is that it's waiting to see what happens in that Scrimeti case that I described, and then it will decide what to do with this case. It will either take it, deny it, or it can do what's called a GVR, which means grant, vacate, and remand. Sometimes it will grant the case, vacate the opinion, and say, redo it, Fourth Circuit, based on the decision we just issued in Scrimeti. So that could be what happens. Most likely we'll see what the court does with it this summer. There's no case pending in the Seventh Circuit yet that I'm aware of. So this is an ongoing issue. Again, a lot of moving parts, but this has just been sort of an overview of where the issue stands. So we're going to stop it there and answer any questions that people have. Please use the Q&A portion if you have any questions, and we're happy to go through the questions that people have.
I see that there's one that says, can districts ignore the executive orders since they are being challenged? This is a good question because there are some executive actions that are being challenged in courts. However, none of the executive orders, and I double checked this while Luke was giving his portion of the presentation, none of the executive orders that we mentioned today have been challenged in courts. Another thing to mention is that the Trump administration now is running the Department of Education and with it, the Office of Civil Rights. If the Trump administration wants to issue executive orders on how to actually implement Title IX and how they're going to do some of these investigations, so long as they comply with current federal law and the Constitution, they are able to direct the agencies to act within a certain set of guidelines, which is what they're trying to do with these executive orders. So, if a school district were to ignore the executive orders on Title IX, it could be very likely that a Title IX investigation would be opened into the school district, and the school district could be at risk of losing federal funding, which the Trump administration has said that they're going to do. And as I mentioned earlier in the presentation, there are at least 4 Title IX investigations that are going on around the country that are using these new parameters in order to investigate the Title IX issue.
So I'm going to answer the one from Glenn and the sort of anonymous attendee. So as Lauren mentioned, the one of the main executive orders on this topic, primarily what it does is it directs the heads of the agencies to come up with a plan in 90 days. So it isn't actually the plan itself, it's a direction to come up with a plan. So we're all still waiting to see what that plan is. And when that plan comes out, things will change. I'm sure it will have some requirements in it. School districts will have to review those carefully. There's undoubtedly going to be legal challenges to some of the stuff that the Trump administration does. Obviously, if a court enjoins something that the Trump administration does, school districts wouldn't have to follow that if it's enjoined nationwide. You got to pay attention carefully to the scope of the injunction. But I would say a lot of what the Trump administration is doing on Title IX is simply applying the text of Title IX as it was originally intended. So Title IX uses the word sex. Everybody at the time understood that sex meant biological sex. In our view, the Biden administration is really the one that attempted to rewrite Title IX by adding gender identity. And so a lot of the executive orders, they're not changing anything. They're just reverting back to what the original meaning of Title IX meant. And I put up the sort of explicit text of Title IX regulations that have been in place for 50 years that say explicitly schools can have sex-separated bathrooms and sex-separated sports teams. So I really don't think those two issues are particularly close questions, given how explicit the text of those regulations are. I'm not sure of a clearer way to write into law that bathrooms can be separated based on sex. So it's hard for me to envision an interpretation consistent with that to be struck down in court. I think ultimately it will be upheld in court. But again, it's nuanced and it depends on sort of the specific question that you're asking.
One of the questions in the chat says, which school districts that adopted policies forced on them by the Biden rule, what should school districts that adopted policies forced on them by the Biden rule do? Would rescinding the policy changes be appropriate? That's a great question and a question that we've received many, many times since the rule has been rescinded. So it is the position of the United States Department of Education that the current governing Title IX rule is the 2020 Title IX rule. So those regulations need to be the regulations that school districts are using to enforce and effectuate Title IX complaints and processes, among other things. Some of the Biden-Harris Title IX rule that was implemented in 2024 took away the processes in 2020 that need to be there for school districts to be in compliance with federal law now. So the best thing to do would be to rescind that Biden-Harris 2024 Title IX policy and revert back to the policy that the school district was using prior to the new rule coming out, because more likely than not, the previous policy is in congruence with the 2020 Title IX rule.
The only thing I would add to that is this is especially true with respect to the sexual harassment process in the Trump rule. So the Trump 2020 rule has heightened procedural requirements and substantive requirements for the sexual harassment process. The Biden rule watered that down pretty substantially, both the substantive standard and the procedures. So if a school district uh, similarly watered down their sexual harassment process to meet sort of the lower threshold for the Biden rule, now that that rule is gone and the higher threshold is back into place, uh, your policies may be in violation of the old Trump rule. And so it's very important to update them for that issue in particular.
Another one of the questions states, does the Trump action remove gender identity from the federal government definition of sex also apply to the Prison Rape Elimination Act? That's a good question, and it's one that we can take a look at the first executive order that I talked about, defining what it means to what the definitions are for sex, for man, for a woman. While I am not an expert on this particular act, this particular part of the law, it would be consistent with the Trump administration and the policy choices that they have made to apply those definitions from that executive order to all different areas of the federal law and federal agencies, not just Title IX.
To Nancy's question, so this is a question about Washington State. The governor and the superintendent are giving school districts orders to follow Washington state law instead of the Trump executive orders. This is unfortunately not a question that we can give a definitive legal answer in the abstract because you really have to know the details of what this is about. The only thing I would sort of say generally is you do have competing uh, legal obligations here. So the Trump administration is saying one thing, the state is saying another thing. If they are both directly on point and directly at odds with each other, generally federal law trumps state law. But again, you really have to look into the details of it and try to navigate both of these competing obligations and do your best to comply with both as much as you can. So you need to consult a lawyer on that specifically to dig into those details. We can't answer that in the context of a webinar, other than sort of those general comments.
All right.
Lauren, do you want to answer Anne's question here?
Sure. Yeah, sorry. I was just reading it and thinking about it. So Anne asked, Title IX will remain at the federal level, potentially handled by the DOJ. If the Department of Education is dissolved, states who've passed or plan to pass laws protecting transgender participation in girls' sports, would there be any enforcement mechanism federally? So Luke went over part of this in his presentation, but if a state has a law that is in direct conflict with a federal law, which either could be a federal court interpretation or a statute passed by Congress, something like that, then that state law would no longer be valid. Right now, it's kind of up in the air whether or not the state laws that have these protections officially will be overruled. It's a little bit of a gray area, but as we've mentioned throughout this presentation, if this does go all the way up to the Supreme Court, and it sounds like it likely will, then the Supreme Court, it's likely would uphold the separation of men and women's sports. Luke, I don't know if you have anything to add to that.
Yeah, I'm not totally sure what law Anne was referring to. I just wanted to clarify that to say that the 25 laws that I referenced earlier are states who have laws that say sports must be limited based on sex. There may be some states on the other side that say uh, transgender students must be allowed to play on the sports team that they identify with. Again, I think that would set up a potential conflict with Title IX at least the Trump administration's interpretation of Title IX. That would have to get litigated. Hard to say totally how that would shake out, although the general rule is federal law trumps state law.
Um, just to follow up to Nancy's question, if you have any specific questions about your school district or a particular law, you can feel free to reach out to us. The next slide has our contact information on it. You can just shoot us an email and we'll do our best to answer those individual questions.
Glenn had asked a couple questions about whether we'd have any sort of webinar on DEI stuff. We had a webinar recently that Lauren mentioned on Trump's executive orders. Part of that covered that in part, and so I just encourage you to watch that webinar if you weren't part of it, and that may or may not answer the questions you're looking for on that issue.
All right.
Jennifer's question, that's a hard question to answer. Again, in the abstract, the sort of general rule is federal law trumps state law. There are arguments to be made in certain contexts that certain issues are reserved to the states and cannot be overridden by the federal government. But again, it's complicated and it's context specific, so it's really hard to answer in the abstract. I do think all of these issues are gonna raise some of these conflicts, and so we're going to see some of this being litigated, and we'll see some answers to that in the next few years.
Amy asked that on a state level, high school sports associations have changed their policy to not allow girls or boys in girls' sports, but there's no enforcement mechanism. What should they do? The enforcement mechanism that you could go through, if there isn't one in your athletic association, is to file a Title IX complaint. And there's a couple different ways to do that. If you would like some guidance on that, again, feel free to reach out to us. We'd be happy to direct you to where you can go to file a Title IX complaint or to help you with filing that complaint.
I think that answers all the open questions. I put our contact information up here. Again, if you have any specific questions or ever want to reach out to us about any of these issues, we're happy to talk to you. Our email addresses are here. And we just thank you all for joining.